versus Bell et al.
Good morning.
Good morning. Give us just a moment here. Okay. All right. Why don't you have a seat for a moment? We're taking just a bit of a break. In place, some of us.
some of us.
You may stay put. Okay. Judge Harrell suggested elevator music be played during the
Right.
interview.
We just have Judge Battaglia sing for us.
Well,
Oh,
there
I
could
could
be
do that. It's the
Never
right
mind.
time of the year.
Withdraw that.
Just wait a couple more moments. Okay. Oh, that's quite all right. I don't know. All right. Mr. Swain.
Good morning.
Good morning.
Swain, I imagine you're intimately familiar with the Harwood case that will be argued here in January.
Yes, Your Honor, I am.
What appears to me there's some commonality between the two cases.
I believe so.
And what do you think is the commonality?
Well, I think obviously both cases are declaratory judgment challenges to comprehensive zoning legislation. This case was for the northern part of the county, and the Harwood case is the southern part of the county. The basis for standing that's alleged by the plaintiffs in both cases is the same. They make the same argument that prima facie aggrievement standard should apply to the standing analysis. I think Harwood has a different component to it because it was dismissed not just based on standing, but also based on a failure to state a claim. So when the Harwood case comes before this court, certainly those issues will be discussed at length in addition to the standing issues. But that second component really isn't a part of this case because we didn't get to it in the circuit court. With this case, with the decision of the Court of Special Appeals in this case, the court's decision expanded for the first time certain aspects of the property owner standing doctrine to declaratory judgment challenges to comprehensive zoning ordinances. We feel that this decision ignored the important differences between the types of local land use decisions previously subject to these standards and the mandatory comprehensive zoning legislation that's at issue in this case. We also believe the Court of Special Appeals erred when it held that traffic noise constituted special damages unique to these appellees.
How important to the outcome of this case is achieving a common understanding of what is a land use case?
Well, I think it is important. And I think what the cases, and I'll talk about that at length, but what the cases previously, including the cases relied upon by the Court of Special Appeals, the Superblock 1 case and the Long Green Valley case, as well as this court's decision in State Center, all of those cases relied on localized land use decisions. With regard to Superblock, it was a land disposition agreement. With regard to Long Green Valley, the Court of Special Appeals found that the conservation easement was a land use decision. And in this court, with regard to State Center, it was the development agreement they found to be a land use decision. Now, I think the important distinction to make is all of those decisions at issue in those cases were localized decisions, meaning they applied to either single properties or small pockets of properties.
Well, is there another way of looking at it, which is to say, to call something land use is a very broad and sweeping description. But if you parse it into a subcategory of zoning, and then under zoning, piecemeal, comprehensive rezoning, if you drill down, that becomes more meaningful than just talking about land use.
Well, we would certainly agree with that. And we believe there are many important distinctions between those kinds of localized land use decisions and comprehensive zoning. Not the least of which is that comprehensive zoning is a legislative enactment, not merely an administrative type enactment. Now, of course, all this goes back to the Benarski case, the 1967 case, that first came up with this distinction between, at that time, localized land use decisions versus equitable challenges, declaratory judgment challenges to land use decisions. And what Benarski stated at that time was that with those administrative type rezonings, proximity was the critical element. If you were next to or nearby a property that was administratively rezoned, you have standing. And that makes perfect sense, because all of those administrative type decisions are localized decisions. They're based on the elements of that property and its interrelationship with the properties around it. I mean, you have to show change or mistake for any of those administrative type rezonings. It's an administrative process where you have these individualized determinations. Now, of course, administrative type rezonings are sort of a quasi-judicial proceeding, which was not the case with State Center or Superblock or Long Green Valley. But still, you had decisions made at a time when the citizens really had no participation in those decisions. The only remedies they had were after the decisions were made. Now, you contrast that with comprehensive zoning, which is a completely front-loaded process. With comprehensive rezoning, I mean, first of all, all the counties are required to do it every 10 years. So it's a mandatory process. Comprehensive zoning is a very transparent process. It's driven by petition or applications, mostly that property owners would submit for consideration of a zoning change. So it goes through a review by, in our county, it goes through a review by the Planning Advisory Board, which holds public hearings. Upon those recommendations, it goes to the county council, which again holds public hearings. In this case, there were 4 public hearings on this comprehensive zoning bill. Every citizen has a representative on that county council who can either advance their interest, whether it be to oppose a zoning change or whether it be to favor a zoning change. The citizens have ample opportunity for their own participation because they can show up at any of these public hearings and voice their opposition or voice their support for these various zoning changes. The end result is a legislative action that affects not just these single properties, but affects the county as a whole. And we really think that is the largest difference here. Comprehensive zoning is, by definition, comprehensive zoning. So when the council is considering comprehensive zoning, they're not considering individual property needs or individual property aspects or individual owners' interests. They're looking at the county as a whole, in this case, these districts as a whole, all of these parcels and how they interrelate to each other.
Well, the council doesn't even really consider standing, does it, for people to testify at hearings?
Well, there's no standing. It's not
So you
it's
come
not a
in
court
and sign
proceeding.
up, we'll hear you.
Yeah, absolutely. Everyone has that opportunity. With the council, with comprehensive zoning, there are no adjudicatory decisions or no individualized findings of fact. It consists of classically legislative determinations designed to affect local and regional needs and all property owners within the planning area.
So how would a citizen challenge a comprehensive rezoning, if ever?
Well, a citizen has many opportunities, first through the legislative process.
I meant judicially. I'm sorry.
Judicially. Well, there's 2 ways. Well, there's a couple different ways that a citizen could challenge a comprehensive zoning. Of course, there's the right of referendum, which is a very important right, which upon the joinder of certain other protestants, you can put on the ballot that comprehensive zoning legislation. Now, it's always been the law, at least it's always been the law that a property owner whose property is rezoned has standing to challenge a comprehensive rezoning. And the reported cases indicate that person really has to make no showing because their property's been rezoned. No question that they have been specially affected by that rezoning ordinance. Now, Where we want to draw the line and where we think the line should be drawn is this concept of proximity being the determining factor. That if you simply live nearby to a property that's been rezoned, then you have standing automatically to challenge these zoning decisions.
Well, if you have standing to challenge a comprehensive rezoning if you own the property, why wouldn't the adjoining property owner also have standing in light of all our analysis, case law, regarding zoning decisions generally?
Well, I think there are several reasons. Number one, simply by being a nearby property owner, you don't acquire any legally protectable interest in the zoning of an adjacent property. You simply don't. That's not a property right. Even a property owner does not have a legally protectable interest in the zoning of their own property. So what the Court of Special Appeals decision does is sort of stretch that and say, well, now you do. Now you have a legally protectable interest in the existing zoning of your neighbor's property.
Well, if you're right next door, you have a prima facie case for standing, right?
Well, that really is the issue. If you're right next door, historically, you have had a prima facie aggrievement in administrative-type land use decisions.
Yes.
That has been extended to certain, really, the cases that it's been extended to have been these public-private agreements between the city of Baltimore or the state and private property interest. Now so they've extended it to that and said that's close enough to the type of land use decisions we've already said were appropriate.
In the case where we said that an individual had standing to contest a comprehensive rezoning if it was his or her own property, what did we rely on, or was it statutory?
It's not statutory.
What
it is.
case is that?
Well, the Anderson House case is one of them. There's a number of cases that are cited in the brief.
And what was the rationale?
Well, the rationale was because he owns property that was rezoned, of course he has standing because his property interests are absolutely affected by a zoning change.
And is it such a big leap to go from there to, of course, these prima facie people also have zoning?
Well, it is a big leap. It is a big leap. And it's not, in the context of the State Center case, Long Green Valley, and the Superblock case, it wasn't such a great leap because you're still talking about localized decisions. But here, with comprehensive rezoning, and understand that when the county goes through comprehensive rezoning, we are, from the bill, and it happened in this case, we are wiping out all the existing zoning on every parcel, 59,000 parcels in this case, wiping out all the zoning, and then we're reimposing zoning on those properties. Most of them have the same zoning. Some of them have different zoning. So in this case, 264 separate properties were rezoned with different type zoning. Now, again, what the council is looking at is not parcel A or parcel B. They're looking at the big picture. And a perfect example of that is two of the amendments that are relevant in this case. Amendment number 34, which is in the record extracted, page E60, was the amendment that Mr. Bell and Mr. Chapin complained about, because that amendment rezoned certain parcels near their house from residential low density to commercial. Now, what the plaintiffs don't talk about is that same amendment also rezones certain property near their house from commercial to residential. So we call that the average reciprocity of advantage. You do comprehensive zoning, you're going to burden some properties. You're going to benefit some properties.
Well, you're going to the merits of their case, though, aren't you?
Well, no. I think that this really is the rationale behind this kind of limited standing. Because, again, when you're looking at what Mr. Nelson is saying is proximity is everything. We're here, we're next door, we have standing. What the county is saying is that's not quite the situation, because when we're making these decisions, we're not making a decision about your property. We're making a decision about the entire county. So even though your property might be burdened, other properties are benefited. And on the average, that's how it averages out. The same with Amendment 25, which Mrs. Shorter is next door to the parcel, one of the parcels that was rezoned in Amendment 25. That same amendment also rezones property from residential to open space. So while she may be more burdened by that than someone else, she's also benefited by that other rezoning.
But let me, again, I don't understand the argument that you're making, because it seems to me it does go to the merits. Because are you saying that if an adjoining landowner is burdened by rezoning, but there's another landowner that may be benefited by rezoning. Is that what you're saying?
I'm not saying that. I'm saying that she may be burdened by a rezoning, but at the same time, she's benefited also by a rezoning because there's another parcel very close by.
How close by does it have to be?
Well, I don't think you get to that analysis. I think what I'm trying to enunciate is that
Go ahead.
with the comprehensive rezoning, you're looking at sort of these regional concerns, and that's really why we feel the harm, when you're looking at harm from a comprehensive rezoning, you're trying to look at how this individual property owner is affected differently than everybody else.
But isn't it part and parcel of your argument that, well, we're not really going to look at this on an individualized basis?
Correct. That is correct.
So the individual living next door doesn't really have the benefit from the other. Let's say one piece of land is rezoned favorably. Doesn't really have the benefit of that rezoning favorably because it's not really very near to where he lives. And under your theory, well, that's an unavoidable consequence of the theory of comprehensive rezoning.
Well, I really believe it is, and I think when you look at administrative type rezonings, you are looking at the focus of that individual property and its effect on surrounding landowners, and that's the kind of proof you have to put in to get a rezoning. Comprehensive rezoning, they're not concerned with this parcel or that parcel. They're looking at the good of the county as a whole. And while certainly, so really the question becomes, how are you harmed by it uniquely from anybody else? How is Mrs. Shorter, for instance, harmed by it any differently than anybody else in that district?
What if the council did a complete rezoning, but the only change they made was to one parcel?
Well, that's a very good question. Now, we feel that under the Court of Special Appeals decision, under existing law, prior to their decision, you have 264 parcels that were rezoned. Those 264 property owners automatically, more or less, have standing to contest that zoning. What the Court of Special Appeals decision does is it says, okay, not only you 264 potential plaintiffs, but also anybody who is nearby or adjoining. So instead of having a couple hundred potential plaintiffs, all of a sudden we have several thousand potential plaintiffs. And in your example, every time a rezoning, a comprehensive rezoning is redone, every property is rezoned because we have to repeal the existing zoning and then reenact new zoning. So in that situation, every single property owner could make that argument that we have standing. So instead of having a couple hundred or a couple thousand potential plaintiffs, you've got 60,000. Now, the Court of Special Appeals and Mr. Nelson discounted that, and they said, well, we only have a couple in this case. But that's this case. And when he filed this case, he knew that there was no clear precedent that said prima facie aggrievement applies to declaratory judgment challenges to comprehensive zoning legislation. I would certainly expect enterprising attorneys such as Mr. Nelson in the future to further stretch the Court of Special Appeals opinions to its extreme. And then you have a situation where you really don't have standing. Just anybody can protest. Now, the problems that creates for the counties.
Before you tell us the problems, I'm going to do you a favor and let you know that your lights went off when you were not looking. So you're into your rebuttal and have been for about a minute or so.
I'll carry on just another moment.
You want to,
Okay.
okay.
The problems. Well, I thought it telling that the Court of Special Appeals said we can perceive no logical or practical reason for differentiating between comp zoning and the types of decisions in the superblock line of cases. The problems that we see with it, first of all, the expansion of the number of potential plaintiffs. I just talked about that. Second, you have the bigger problem of uncertainty in comprehensive rezoning. Now, when you go through an administrative rezoning, there's a 30-day window to appeal that decision. And once you get past that 30-day window, you're good to go. Now, with comprehensive rezoning, under the Court of Special Appeals decision, that window is 3 years. So you have a 3-year window where you have to wait for any one of these various plaintiffs, including plaintiffs with innovative theories, to come forth and say, well, we don't like your zoning. So you have a 3-year hold, more or less, on development of that property. Now, if you go through a administrative rezoning, you have a 30-day period. Now, what possible rationale could there be for that basis to punish the comp zoning recipient while rewarding the administrative zoning recipient? We see that as a problem. We also see a problem that under the Court of Special Appeals decision, it conflicts with the well-established law that a property owner has no legally protectable interest in their own zoning. What the Court of Special Appeals opinion is saying is, if you're nearby, you have a legally protectable interest in your neighbor's zoning. Now, that's never been the law in the state of Maryland. So we do believe there are practical and logical reasons why the Court of Special Appeals decision is flawed.
All right.
Sit down now.
Okay, thank you, Mr. Swain. Mr. Nelson?
Please, the Court. Macy Nelson on behalf of the citizen protestants in the case. My adversary has characterized the rule of the Bell case as creating the phrases, quote, automatic standing, end quote. Counsel uses that phrase in his brief. He used it again in his oral argument, and we reject that characterization. It is a shifting of the burden of proof. Judge Moreland described it in the Court of Special Appeals Ben Ray case as a shift of the burden of proof which achieves a procedural shortcut to aggrieved status. Super Block 1 quoted Sugarloaf, which talks about the shifting burden of proof. So what the rule is that if someone meets the test for adjoining, the burden of proof shifts to the adversary to come forward with evidence that the protestant lacks standing, lacks evidence of agreement. And so in the Bell case, for example, in this case, in the trial court, my adversaries raised standing. We argued it. We submitted sworn testimony. It's in the extract. Affidavits from Rosie Shorter, affidavits from Messrs. Chapin and Bell. No response. They had every opportunity to come forward with evidence. So it's a shifting burden of proof. It's not automatic standing.
Mr. Nelson,
Yes, sir.
Let's hypothetically, if the county council had passed a bill that had nothing to do with land use, it had to do with pensions.
Outside my area.
Huh?
Outside my area. But
Well,
okay.
I don't care about the substance of the law itself. It's a bill about pensions. And a client came to you and said, I want to take that to court. I think there's something legally wrong with it. What standing would that person have to demonstrate in order to bring a declaratory judgment action challenging the constitutionality or other illegality of that bill?
Well, of course, I'm an advocate, and I would try to educate the client on the difficulties with standing. I'd say, we have these line of cases beginning in Super Block 1 talking about land use, and I'm a land use lawyer.
We're not talking about land use.
I know.
We're
So
talking
I'd
about anything but land use.
Right. So I would say, we got to sort of, I wouldn't say this out loud to a judge, but we got to sort of move that to one side. I would tell the client. Then I'd say, I want to show somehow what your stake is in this controversy, and we got to figure out what the bill does and how it affects you, and then we need to construct the most powerful and objective, fact-specific case we can as to how it affects you.
Would you agree that the cases say that you have to prove a special injury separate and apart from that would be suffered by the public at large?
Well, I would make every effort to try to prove that, yes, sir.
No, don't you think that's what the cases say?
Well, it's
How you establish standing to challenge a legislative enactment that has nothing to do with land use.
I think so. But I want to look at all that jurisprudence, but I think so. And what this shifting burden of proof does is it short circuits the process, and what it says is, look, we're gonna put the burden on the adversary in this case to show that a citizen protestant who challenges a comprehensive rezoning is not aggrieved in a way that's different from the general public. So it's just simply a shift in burden of proof, in my view.
So in the end, you have standing because there was no response?
Well,
Is that what you're saying now?
no, we proved standing, but I'm also making the point that there was no response. They had an opportunity to refute it. I think any reasonable person looking at the affidavits in this record from Messrs. Chapin and Bell and Ms. Shorter would say that makes any case for standing, in my view. But there was no response. The point I'm trying to make to the court is, under the law, there is the opportunity to refute the standing. They have their burden of proof. It's not a criminal burden of proof. It's preponderance of the evidence. Let them come forward with some evidence to show that Messrs. Chapin and Bell, who live 80 feet away, aren't adversely affected. They didn't do it.
Well,
I'm sorry.
might one say that that the argument that the county is taking now is that in a situation like this, it's not a fact-based determination of whether they're standing. If in comprehensive zoning, you have your right to appear at the hearing, you have the right of referendum, and that's about it. And that gives you quite a bit of maybe I misunderstand the county's argument, at least to some extent.
I missed the court's question. I'm sorry.
Well, then if it's a legal question, you either have it or you don't. But the county seems to be saying that your clients don't have standing here to contest this particular determination by the county. So why would that be why, if they're correct, then does this short circuiting of shifting burdens on the facts, does that even apply?
I'm worried that I'm not grasping the court's question, but if the court is saying, is there a factual inquiry, if there's a challenge to a comprehensive rezoning, is there in any circumstance a factual inquiry as to someone who's abutting the property?
Right.
Well, of course there's a factual inquiry. They chose not to participate in it, right? The Super Block 1 talks about the shifting burden. Long Green Valley, Judge Kenny talks about the shifting burden.
Counsel, but if your client, as a matter of law, does not have standing, why do we get into any type of factual discussion, as the Chief just pointed out? I don't understand.
Well, I'm sorry. I thought we were talking about the declaratory judgment actual action in the circuit court.
No, I was.
Yeah.
Judge Green understood my question, and perhaps.
Yeah, as a matter of law, that's what I understood to say. As a matter of law, the point is that your client has no standing to go forward in this
Well,
case.
didn't you have to establish in the affidavit where the client lived or owned property?
We did that with explicitness.
No, but that's my point. Isn't that what the affidavit was for?
Well, no, we can go to the record, look at the affidavit. I'm sorry, there's two questions pending. And
You
I
can
come
handle
back.
it.
You can answer mine if you don't mind.
Okay. Well, excuse me, Judge Ackman. I don't accept the proposition that someone, as a matter of law, doesn't have standing to challenge comprehensive rezoning. Under the county's view of the law, which I reject, they say that only people who can show special agreement under the classical case, not prima facie. And what I'm saying is I get that standing plus prima facie standing. And prima facie standing, Your Honor, is not automatic standing. All it means is they have the burden to prove.
I understand your point, but what I'm trying to understand is if, as a matter of law, you can't point to any case law that gives you standing, then doesn't that put you out of the ballpark?
Well,
Or it doesn't even get you to first base, I don't think, would it?
well, I'm looking at Super Block 1, prima facie, for land use decision. I'm looking at Super Block 3, which distinguishes a memorandum of agreement and which says a land use decision, this is at 426 million at 30, is a decision typically an ordinance or a regulation, now I'm paraphrasing, that's promulgated for the purpose of directing the development of real estate.
So you don't accept Mr. Swain's argument that this is not a administrative land use type case. You don't accept that argument. Is that the point?
This is not an administrative land use type. This is
Nor was it in Super Block.
a big part.
I say, nor was it in Super Block 1.
Comprehensive rezoning. I'm sorry.
No. These were acts by local government that were characterized as land use decisions, even though they were not a rezoning of property. But they affected how land was used. And that's how that phrase came into the court's opinions in those cases. They were not legislative
Correct.
Enactments either.
Correct. I agree.
Which is why I think that at the core of this case is you're looking at a legislative enactment. Just as if it were a bill passed by the General Assembly, signed into law by the governor, what would somebody challenging the legality of that enactment have to prove to have standing to have a court engage in judicial review of it?
Right, but those cases don't have a whole body of case law behind them, beginning with Superblock and following, and that's why
But those were not legislative enactments in
Right.
Superblock.
Yes, Judge
And it
Harold.
wasn't a legislative enactment in the state center case.
Right, but you're right, and this is why I read so carefully all the cases, including Superblock 3, because I acknowledge Your Honor's point. This is legislative, those were not. I understand.
And there may have been a legislative body
I understand.
involved in doing these things in the non-legislative act cases.
Right,
But that shouldn't determine that you swap over that analysis into a case that is a legislative enactment.
Well, then I look at Superblock 3 at page 30. Generally defined, a land use decision is decision, typically an ordinance or regulation, enacted or promulgated by a legislative or administrative body for the purpose of directing the development of real estate. And then I say to myself, why should we have this rule, this prima facie? Well, I believe the rule makes sense is that because Bernarski was trying to, in essence, codify the rule of standing, was trying to simplify, create a lot of work in the process, but try to simplify the rules governing standing. And so what it did, it recognized the reality on the ground, which is if someone's right there, they probably have standing. Let's put the burden on the adversary. If someone's a little bit further away, let's put the burden on them. And I think that in these land use cases that it makes sense to adopt that rationale to a comprehensive rezoning, because the phrase is comprehensive rezoning, but you know what? It's not comprehensive rezoning. The comprehensive rezoning is only comprehensive in the sense that they're looking at the county, but every land use decision is a street fight. There's intense lobbying, both sides, to the applicable county council. So to call it comprehensive rezoning, to call it regional planning, is not in tune with the reality on the ground. And I believe that if we adopt, if this court extends the rule of Superblock 1, of Superblock 3, of State Center, and the Court of Special Appeals, Long Green Valley, and the Bell case, and those were both carefully written by thoughtful judges, in my opinion, who understand real land use, it makes sense to apply that rule here. It's going to streamline the process. And it doesn't mean there's automatic standing. All it does is it recognizes the reality that Rosie Shorter, whose land touches the land that is rezoned, who's not a person of means, she probably has standing, and if they think she doesn't, let them come forward with some evidence. So, Your Honor, I acknowledge that this is legislative. The other cases were not. I believe that the dicta in Superblock 3 helps us here, and I believe that there's a powerful reason for the court to apply the prima facie rule to comprehensive rezoning. Thank you all.
Thank you, Mr. Nelson. Thank you very much. Mr. Swain, you have a few moments left, I believe.
I do want to be very clear that the issue the county takes with the Court of Special Appeals decision is the extension of these prima facie agreement and almost prima facie agreement to legislative enactments of the county, like comprehensive rezoning. We believe that they are completely appropriate for administrative land use decisions, and I can understand certainly the extension of those principles in the State Center case, in the Superblock case, and in the Long Green Valley case, all of which were localized land use decisions. The problem the county has with that is comprehensive zoning. A legislative act, which is entitled to a presumption of correctness, is different, has always been treated differently, and should continue to be treated differently. We believe the Court of Special Appeals opinion should be reversed.
Do you personally think it was improvident for this court and the Court of Special Appeals to have even used the phrase land use decisions to characterize?
Well, it's a bit of
core of State Center, Superblock, Long Green Valley.
Well, it depends, because when you talk about land use decisions, some counties do use ordinances for individualized rezonings. There are things that can be done along those lines. I think that requires saying that a legislative act is a land use decision. Now, certainly it bears many of the components of a land use decision, but it's not. The reason it's different is because it has to go through the legislative process, which none of these other agreements had to go through. So we think that is the difference, that while it may share the components of a land use decision, because it does direct development in the use of real estate, it's not the same because it is comprehensive and because it is legislative. Thank you.
All right, thank you, Mr. Swain. Thank you, Mr. Nelson. Next is number 28.